all-time interesting segment of Talk Show with the Experts on TVASIA Telugu. ఇమిగ్రేషన్ అండ్ వీసాకి సంబంధించి ఎంతో మందికి ఎన్నో సందేహాలు. ఆ ప్రశ్నలకి ఎక్స్పర్ట్ అడ్వైస్ ఇవ్వడానికి ఇవాళ మన ముందున్నారు రాహుల్ రెడ్డి గారు. He is an eminent lawyer and founders of Reddy Neumann law firm based out of Houston, Texas. Welcome to the show, Rahul garu.
Thanks for inviting, Sita garu.
Thank you so much, Andy. Very happy Thanksgiving weekend, Miko.
Sure, same to you.
Today's topic is really Biden's plan on business administration, which is not very clear, Andy. Now that the whole transition is going on, how come we do not have much clarity on what is President Biden's, what he wants to do with the business immigration?
He doesn't have any plan. At least he did not express it in the election, at the time of election. He did not put it on the website. Before the elections, normally they put the immigration policies. They express, in the debates also, what happened was that they completely bypassed the business immigration. Definitely, this Joe Biden administration they do have a plan with regards to other immigration. For example, political asylum, EAD, employment authorization to the children who came under 51, which we call them as DACA kids. He has a plan for them. He has a plan for asylum applicants. He has a plan for kids getting separated from that of the parents in the process of the political asylum or the deportation process. Now, he has plans for everything, but he does not have any plans whatsoever at all on the H-1Bs. He doesn't have any plans on L-1s. He doesn't have a plan on how this information technology growth is going to, the immigration is going to contribute to the information. He does not have any plans. He did not express. So we don't know how he's going to proceed. He's been projected to be the centrist candidate. He's definitely not a left-wing guy. Normally, the centrist candidate should be good for business immigration, but as such, he has not expressed anything at all. To add that, as we have expressed in the past two things about Trump is trying to damage the business immigration as much as possible, and he is touching everything that he can. Now, once the Biden administration is going to come into power on January 20th, though, the first things that he's going to lit, the fires that have been lit, he's going to put off are not business immigration. It's going to be about political asylum. It's going to be about DACA kids who have been given employment authorization. But when it comes to the H-1B, especially in the past preceding 2 months, though, what we noticed is that there is a new regulation that is kicking on December 8th.
Right.
That is going to make it very unlikely to get any H-1B for a period of 3 years, especially if they are working for the computer consulting companies. That means that every year we have to file a H-1B extension for most of the H-1Bs. And also the specialty occupation definition has been redefined. On October 8th, there was a new regulation that went into for the labor, increasing the wages to approximately 40%. So this is, a lot of companies are waiting to see if there is any court decision that comes in favor. Unless the court comes in favor, though, the Biden administration, when they come into the power, we are not expecting them to undo all the changes. Even if they want to do it, they may not be able to do it because these are passed in the regulations. They have to be done in regulations only, and then will take years for Biden administration to do. There are certain things, the executive orders that were passed in. He may undo some of them, but when it comes to business immigration, he may not do any of that. So we may expect some prolonged torture of the immigrants, at least for the business immigration. He may not come to immediate help for us.
Okay, so something that we are seeing so far may continue for a few more.
That is absolutely right. It is expected to continue. I want to tell the audiences that, hey, don't expect any miracles to happen. Don't accept to file the H-1Bs later on. Try to file before December 8th because the laws are changing on December 8th. So it's only like 8 days left for you to file a H-1B. Try to file the extension as soon as possible.
Okay, so that's the advice we have. Be quick. So we have a lot of callers and questions waiting, Andy. Let's take the first caller here. The first caller, let's admit the caller ending with 0897. And also in the meantime, let's take a YouTube question. It is from Arun T. The question is, what happens if my old employer withdraws I-140 within 6 months of filing 485?
When he says old employer, Arun, I don't understand. Do you mean to say the underlying I-140 application for which you filed the adjustment of status? If they withdraw the I-140 and they withdraw the offer of the job for you within 6 months after you file the adjustment of status, that means that your 485 will be automatically denied. You have to have the job offer, continuous job offer, for the next 6 months after you file the adjustment of status. Now, when you meant the old employer, if you mean to say that you file the I-140 and adjustment of status based on, let's say, for example, company B that you are working for right now, but you had a I-140 with company A previously with a different company though, okay? Assuming that I-140 has been approved for a long time ago, if the previous company withdraws the I-140, it will not have any negative. It will not have any negative impact on this one. But if it's a current company that is working that filed the I-140, the end adjustment of status right now, his 485 will be automatically denied.
We have the, I think we lost, we are losing what Rahul V was mentioning. He's gone on mute.
Hello.
There is some noise we have from the background, and 0897. That is the caller. Can you please go on mute for 1 minute while Rahul is explaining the question?
Okay, I'm done. And we can go for the call now.
Okay, that's good. Do you hear us, Andy? Can you ask your question? I think we lost the caller, Andy. Let's admit the next caller here, and let's take the next question. It is the caller ending with 0813. Please go ahead with your question. Caller ending with 0813. Okay, that's good. Can you hear us, Andy? Can you ask your question? If you're hearing us on YouTube, there could be some lag. Please try to ask your question here. We can hear you now. Caller ending with 0813.
Yeah, hi. I have a question. So I'm downgrading from ED2 to ED3. My I-140 was approved with the same employer earlier in ED2, but it was originally approved from a different employer and it reported to my current employer. And when they file AOS with the downgrade, they did not file 485J. Is it mandatory to file 485J?
No, it's not mandatory. If it's not mandatory to file a 485J. If they are filing an I-140 along with the 485 application, they do not need to file a 485J supplement. When they file just a 485 based on the already approved I-140 without any downgrade, that means that standalone 485 application, you have to file a 485J supplement. In your case, there's no need to file a 485J supplement.
Okay, and I have one more question, sir. My application was filed like more than 30 days ago, 35 days ago.
And you didn't receive the receipt notice, yes.
Yeah.
I
emailed the logbox.
Yeah, it's common. They're behind between 6 to 8 weeks right now. I would say a little bit more than 6 to 8 weeks. I would say they're saying it's 6 to 8 weeks, but I would say between 7 to 10 weeks is what they're lagging behind right now.
Okay. And in case my EAD is not approved within 6 months, right? So I should stay with the company at least until that is approved, right? Beyond 180 days? Until
Not
EAD
necessary.
Is approved?
Assuming that if you're I-140, one caution that I want to tell you though, I want you to wait after the I-140 is approved for at least 180 days. Even though it's not a legal requirement, I would say that there may be some complications if the current company withdraws the I-140 within 180 days after you file, after the I-140 is approved. I want you to caution that though. And whenever you move to a different company, you need to file the 485J supplement. If you don't file a 485J supplement, this 485 can be completely denied. Be careful on that, okay?
Yeah, sure. But for that, EAD should be approved, right? Before that, if EAD is not approved, we cannot even
necessary.
Oh.
Not necessary. because you are on H-1B right now. If the EAD is not approved, you can always file a H-1B and move to company B. Can you not? Yes, you can.
Okay.
But make sure that even if you file a H-1B, do file the 485J supplement.
Okay. Okay. That makes sense.
Okay, then. Thank you for
Okay.
tuning in.
Thank you, sir. Appreciate your help to the community.
Thank you, sir.
Thank you so much. Let's take the next caller here. The caller ending with 3942. And before that, we'll take the next YouTube question. Again, it is from Arun T. Andi. He's asking, do you suggest applying for H1B, H4, H4 EAD in normal processing and upgrading to premium after H4 biometric appointment is done?
We have suggested a long time ago to do this plan because we don't know what was working, what was not working.
Right.
When the biometrics were being introduced in 2019. However, though, that method, that premium processing, you upgrade it after the biometrics are done, is not working for H4. Practically, it's not. So what we expected was that if after biometrics is done, premium processing is done, we expected H4, H4 EAD, and H1B will be approved at the same time, but that's not happening. So right now, timing of the premium processing has nothing to do with your H4 application. It's just independent. They are not approving H4 plus EAD along with the H1B, no matter what you do.
That's sad to know, but sure. We have the caller here. Yes, go ahead with your question, sir.
Hi. I am on H1B and my I-140 is approved with priority date in December 2019. My wife is on H4 and she went to India in March. Before she went to India, she graduated here on H4. She graduated with her master's and she went to India and got stuck there. And she came back with H4 visa interview happened in September, beginning of September or ending of the August. So she got the visa interview with an emergency appointment since I was here, and she came here on September 10th. And then as soon as she came here, within few days, our priority date, which is December 2019, it got the current and we filed 485 immediately. Since she is here, we filed it together.
Good for you.
And then, yeah, thank you. And then my receipt number came in, hers didn't come in, and we inquired since it has been, we applied that I-485 on the very first day, which is October 1st. And then we were waiting pretty long and we inquired and we came to know that her application got rejected. And the rejection details are yet to know because that's on the way back to home. And they did not deduct money as well for our application.
But since the priority date is still current, right now, you can file her application right now.
So we filed it, but it was rejected. My worry was that...
Sir, the priority date is still current for her, is that right? You are in EB1 category, is that right?
Yeah.
The priority date is still current right now. So if the application is rejected, you refile the application.
Yeah. So my question is that there is something called 90 days rule. Is that what we are anticipating?
90 days rule is not applicable to your wife. Your wife came into United States on H4 or L2, is that right? Either of these applications.
H4, please.
Yeah.
H4.
It doesn't matter whether it's L2 or H4. The 90-day rule is not applicable to your wife.
Wonderful. Okay. So we can apply immediately. Once the application come back immediately,
then you can look into the deficiencies and reapply. Absolutely no problem with it.
And the question number 2 is that like my credit card score was too low and I used it up and will that cause any problem?
I'm assuming that your income is $60,000 or more per year, your family income is. And
no.
You're good. Is it yes or no?
No.
More than 60,000?
No.
It's less than 60,000?
No. It is 51,000. We are researchers.
You're good. Yeah, you're good. You're still good. 51,000 is still good enough. Even if your credit score is lower, it should not matter for you. You should be fine.
Wonderful. Thank you, sir. Thanks a lot. Rahul Garu, Chana helping me talk. Thanks a lot.
Thank you so much. Well, we have the next caller here, Andy. The caller ending with 0403. Let's admit the caller. And before that, we could take another YouTube question. It's from Rockstar Andy. What he's saying is, when I applied for I-485, my wife was outside the country, and after that she came to USA using H4 visa, and dates are not current now, and I can't apply.
No, he cannot apply. If the prior dates are not current, he cannot apply. Unless our previous caller, his priority dates are still current right now, so his wife can reapply. But in this case, since his wife was not there, the priority date went back. She cannot apply. She has to wait for the priority date to become current. He and his wife have to maintain the legal status so that they will be eligible to apply the adjustment of status when the time comes.
I guess there is an extension to the, it is the same question. I think he says I can't apply the I-485 for her, and my current H1, H4 expiring in next month, and employers also are not ready to do my H1 or H4 extensions. What are the options for her to stay in USA?
She has to leave the country, or she has to apply for an independent visa if she's eligible for it.
Okay. So let's take the caller here. I think we lost the caller. Yeah, we have the caller ending with 5341. Please ask your question, Andy. If you're hearing us on YouTube, there could be some lag, but you could ask your question here on the call, right? The caller ending with 5341. Possibly you're on mute on your phone. Please unmute yourself. Let's take a question from YouTube, Rahul Garu, in the meantime. It is a question from Sunny D. His question is it okay to pursue online or part-time master's or PhD program while on H1B? Is it okay to have a YouTube channel on H1B?
The first one answer is very clear. The answer is yes, you can pursue the PhD while you're on H1B. Absolutely no problem with it. The second one is that, is the YouTube channel for the purpose of making the money, or is it for the purpose of entertainment only? As long as it is completely entertainment. And now there are some people who are telling that, oh, YouTube channel is just sending us checks. They don't send checks to us, to me at least. We do have a YouTube channel. So you must give tax ID number or your social security number for them to send a check. So I'm surprised in what way. So as long as the YouTube channel is only for the entertainment purposes only. I mean, I have a passion. Let's say I like Tesla cars and I like to publish all the things about Tesla cars. I don't expect anything in return to that thing. That is perfectly okay.
Okay. I hope you have your answer, Sunny. So let's take the caller's question. I hope you're ready here, Andy. Yep. Please go ahead.
Just go ahead.
I have two questions. The first question I have is I am working as a full-time employer and I downgraded from ED2 to ED3 and filed my 485. My question here is I'm expecting a promotion sometime in the next year.
You're expecting what? You're expecting what?
Can I promotion?
Okay.
Promotion, designation change. So my question is it any risk of accepting the promotion, or is it fine?
We call a natural increment in the position should not harm your I-140 or adjustment of status application. So a incremental promotion, according to me, is a natural thing. It should not affect. That's my opinion. That's the opinion of the immigration. Now, the question that is it a natural promotion? Is it an unnatural promotion? For example, if you are a software developer, you are becoming an architect in software, okay? Architect in software. Is it a natural promotion? Yeah, it's a natural promotion. What if you are promoted to be the lawyer of the company? That doesn't look like a natural promotion to me. So as long as within the same field, you are having a natural promotion, natural increment in the position, I don't see a problem. Now, this natural increment should be the belief of the employer and employee also. If they don't believe it's a natural increment, then it is not. So you have to look into yourself, is it a natural promotion? According to me though, as I said, if you're moving from software developer to a software architect, I think so, that's a natural promotion. According to me, if you move from software developer to a lawyer, I don't think so. That's not a natural promotion. Now you tell me, is it a natural increment or is it a different? Yeah, I think so.
It's a natural increment. Senior manager.
Sounds good. Sounds good. You're good. Senior manager in software itself. So you're good.
Awesome.
And second question I have is, it's for my spouse. She was working on H4 EAD and due to the delay in her new H4 EAD, she stopped working. My question here is, can she do trading, stock trading, while on H4 status?
She can do stocks trading. It is not considered to be working as long as she is trading your own family money and not taking any money from other people. I don't see that as a problem. I don't see that as, it is not considered to be working. Okay?
And she can use as a 401k funds and she can do.
Absolutely. Absolutely, she can do that.
Thank
yeah.
you so much. Let's take the next caller here,
Thank
Andy.
you so much.
Thank you so much. Thanks for the patience and the answers, Rahul Garu. Here we have the next caller here, a caller ending with 5003. Before we take the caller's question, let's have a YouTube question. It is from Murli D. So he says, my daughter's age is out in exactly like 18 months. And sir, we are able to hear you. Can you just go on mute before we, while we are taking the YouTube question? We'll get back to you in a minute.
Yeah, go ahead. So daughter is becoming 21 in 18 months.
Yes, in 18 months. And my priority date is June 10, 2010 in EB2. I downgraded to EB3 along with adjustment of status. Should I upgrade to premium or stay normal to avail CPA? That is the question.
Very good question. Very good question. CSPA. I would not do premium processing for this guy.
Okay.
I would not. The reason is that the I-140, the time period the I-140 is pending, freezes the age. I mean, the age of the kid will be deducted from it. So since he wants to avail, she's getting 21 in 18 months. We don't know if the final action dates will become current for him soon or not. We don't know. So I do not like to do premium processing for this particular person though. Now this is an exception. For all other people, if the age out kid is not involved, I strongly recommend premium processing, but not for this gentleman.
Okay. Awesome. I think that's your answer, Murli Garu. So here we have, please go ahead, Andy, with your question. The caller ending with 5003.
Hi, Sita Garu. Can you hear me?
Yes, sir. Go ahead.
Hi, Rahul Garu. I watched your webinar on Tuesday. That is for, you told that the court will issue summary judgment that will be against DOL for wages.
Well, no, wait. I didn't say that they will. They will issue the judgment, but it may or may not come in our favor. I can't predict what the judge is going to do it in advance. I hope it comes in our favor.
Okay. Good. Okay. So my question is, if the judgment is against DOL, so can DOL bring another new wages increasing with new regulation?
They can, but now the administration is changing right now, is that right? If they want to bring in regulations, though, it will take a long time to formulate those things. And the administration is changing on January 20th. So very unlikely that they will bring any new legislation, new regulations soon. If this is gone, at least for a period of 1 to 2 years, we're safe.
Okay. Yep. Thank you.
Thank you then.
Like you were mentioning.
Thank you.
Good. Thank you, Andy. Like you were mentioning, there's not going to be tremendous changes or some miracles to happen with the new administration.
Yeah, but we are expecting but he rightfully pointed out though, it's the courts that we are relying on, especially on the prevailing wage issue. The way they increase is completely illegal according to me. I mean, according to all legal scholars I've spoken with, it's completely illegal. So there is a good chance that the court may issue in our favor.
Awesome. I hoping for the best as always. So we have a YouTube question. Let's admit the next caller ending with 9522. And before that, let's take the YouTube question, and it is from Anish Kumar. He says, my birthplace is different than the one mentioned in the passport, though it is in the same district. should I mention both city and state in the I-485?
I like to know exactly how different it is. I mean, is it, when it is different, like I know that Hanmakonda, Warangal, I mean, Hanmakonda is a city, Warangal is the capital. So Kakinada and with Godavari. So it could be that. I don't know exactly what he meant. Okay. But if it is reflecting the truth, I mean, the actual thing, Hanmakonda and Warangal district or Kakinada and Godavari district, yeah, there is nothing wrong in mentioning everything in there. Mm-hmm. So that when questions are asked about it, then they're fine. But if the Kakinada and then it says Krishna district, which is definitely not, yeah, then I would like to consult a lawyer to discuss what are the options left there.
Awesome. Okay, that's your answer here, Anish Garu. Let's take the caller's question, Anil. Caller ending with 9522.
Namaskaram, Rahul Garu. Namaskaram, Sita Garu. I have a question, Rahul Garu, like open question. I got the receipt, 485. I'm a derivative applicant. Mm-hmm. I got the 485 receipt 2 weeks back. I'm also on H1.
That's good.
My question is, if I lose H1 status, right? Mm-hmm. So still I'm on status to renew my H1 after 3 months or 4 months later?
No. If you lose the H1B status and you pass 60 days and you don't shift to any other status, you would be considered to be married to the adjustment of status application. I want you to go back to 4 weeks ago on that same show that we have to understand the word marriage. You would be considered to be married. If it is within 60 days and you have the I-94, you can move from one company to another company, which you already know the 60-day period is, right? But once you cross that 60 days, you haven't filed a H4 application. You haven't filed a H1B. You are now married to the adjustment of status. You cannot move from adjustment of status to the H1B. The only process is that you file through the consular processing, then you have to go to India to get the stamping and come back, which is a very hard process to do.
So so the default when I
lose the status. If you lose the status, you will be an adjustment of status right now.
Oh, that comes automatically effective.
That's right, automatically. It comes automatically. Okay?
Okay. And second question is, after getting one more open question, like after getting a receipt, 485, 180 days we can transfer, primary applicant can transfer the job to any other company, right? That's 180 days means.
Did your wife filed a I-140 downgrade also, or they did not?
No, she's she's on EB3, straight application. It is on EB3.
Yep. Yes. Yeah. She can. She's working with a company right now. After 180 days, yes, she can move to a different company. But one rule that I want you to be very strict about: make sure she files the 485J supplement to replace the current company. If she does not, there is a chance that they may revoke the 485 will be denied completely. It's a simple process.
So 180
supplement
days.
Is 180
I
days
got
is
it,
the
sir.
time of filing the application, not when you receive the receipt notice.
Oh, filing the application. Awesome. So I have my priority date is earlier than my wife date. It's May 18, 2011, and I'm in EB2. So with current employer, I filed my labor April 2020. So I heard that it is labor got approved, but they didn't receive the labor application. So would you recommend like EB2 and EB3 I can file simultaneously?
Yeah, you can file
because
EB2 and you can file EB2 I-140 and EB3 using the same labor certification at the same time. You can do that. Absolutely, you are in legal limits in doing so. Whether it's going to be useful or not seems to be, I have some doubts because you filed the adjustment of status with your wife. But as far as the legalities are concerned, you're absolutely fine. If the labor is filed under EB2, you can use the same labor certification file 2 I-140s at the same time. Okay?
Awesome. Thank you.
Thank you.
Thank you, sir. Thanks for your time. Thanks very much.
Thank you so much. Rahul Garu, let's take a short break, Andy. Viewers, stay tuned in before we are right back here. Thank you for staying in. We are right after the break. And we have a lot of questions and callers waiting, Andy, Rahul Garu. Thank you so much for the service that you're offering to the community.
Sure.
And I have a question here. This is from 𝗧𝗔𝗟𝗞 𝗦𝗛𝗢. The question here is, can we transfer undergraduate F1 visa to master's degree course within the same university? Is there any recent changes to the F1 visa?
Right now, there is no restriction. He can just transfer from undergraduate to master's degree. He just need to go to the DSO. No, nothing is required right now. However, though, Sitagar, I want to be very cautious on this one.
Okay.
There is a proposed rules that were being published recently. They may become effective. I don't know when they are going to become effective. They can be made effective. If they make them effective, though, there is a chance the same gentleman who is supposed to go from undergraduate to graduate instead of directly approaching the DSO, if this new rules go into effect, what will happen is that he has to apply a thing called I-539 application to the USCIS, and it may take up to 20 months under the current processing time to get that one approved so that he can go from bachelor's degree to master's degree. In the last week, we were telling about, what are the damages the Trump administration is planning. This is one of the damage that the Trump administration is planning. So if this guy is listening to me right now, if he wants to change it, try to change it as soon as possible. Don't wait because the rule might change.
Oh, okay. So Sai, I think you have your answer. That's one of the consequences we have right now. Well, let's take the next caller here. The caller ending with 1128. Please press *6 to unmute yourself.
Hi, can you hear me?
Yes.
Yes, sir. Go ahead.
Yeah, sir, I have a question. Like my employer has applied for adjustment of status, and I know that after 6 months I can change to a different employer. Assume that, I get my green card after 8 months with the same employer. Do I need to still stay with the same employer after getting the green card?
Once you get the green card, you're under no obligations to stay with the company. There's no 6 months rule. There is no 1 month rule. You can leave. You can do anything you want to. Either you can flip a burger in McDonald's or you can be a Microsoft CEO.
Oh, okay. If the same role is applied, let us suppose that I change my employer after 6 months on EAD, after, applying the 485J supplement, and soon after joining the new employer, I get my green card again, within a month time. Then in that case also, I don't have to stay with the new employer for 6 more months, right?
No, sir. You can be working, flipping a McDonald's burger or Microsoft CEO.
Okay. Yeah, I have last question, sir. It is about whenever we change the employers, we know that we have to file 485J supplement application. Do we get any approval notice for 485J? Do we get any approval notice for the 485J?
They do give the receipt notice, for sure. Do they give an approval notice? They do sometimes they don't. Because they may be approving all these things at the time when you go for the interview, though.
I see.
Okay.
My concern is, is there any guarantee that, if I apply for a different SOC code, then, within the same occupation, getting an approval for 485J will give some guarantee that, they accepted the new SOC, right? So
we haven't, let me tell you though, I've dealt with about 10,000 485J supplements, not just with my friends, my colleagues in my office and all those things. As of now, I only got one rejection with a when the person changed the job from company A to company B. He was not my client. He came for consultation and we tried to resurrect the thing. The reason why they denied this guy was that he moved from California to Texas, which is not a problem. He was a software professional, but they found him that he is working as a full-time as a restaurant manager. He filed a liquor license And he swore on the affidavit there saying that the only profession that he is doing is the restaurant management. And they got, the USCIS got the affidavit and asked us an RFE explain how this software profession is related to this one. We failed. Now, anything else that we explained, there was no questions from anybody. I mean, they just approved it.
Okay.
Remember, I was pointing out to another guy saying that you should be in the same profession. Yeah, if they move from there to lawyer, definitely your 485 will be denied.
Okay. Yeah. Thanks so much, sir, for answering my questions. Take care.
Thank you very much.
Thank you so much, Andy. Let's admit the next caller, the caller ending with 1542. Before we take the caller's question, Rahul Garu, here's a question from 𝗕𝗶𝗱𝗲𝗀𝗀 on YouTube. So the question is, my L2 to H4 𝗦𝗂𝗱𝗆 change of status had my new passport number mentioned rather than the one I used at the POE. My husband's H1B change of status was approved effective October 1st. Will this be any issue?
No, it will not be an issue. You're good.
That's your answer. So here we have the caller ending with 0897. Okay, I think we lost the caller. Let's take the next caller. Before we take the caller's question. Yep.
Hello, madam.
Yes, sir. We can hear you, sir.
Yeah, very good afternoon, madam.
We have Rahul Garu.
Rahul Garu, yeah.
Sure.
Sir, actually, I have two questions. So basically, the DOL, it is running so late, right? Actually, June, I applied second week, my perm, almost 174 days it happened. So till then not approved. My actually 6-year extension, it will be completing by Jan 10th actually. So will it take some more time or like no? So you have any idea, sir, about on this?
Yeah, it's taking about 6 months, I would say, to approve it. There are some creative ways if you're thinking about it to extend that January deadline. Maybe you can spend 20 days in Mexico and come back and spend 20 days again to come back. Those are some of the steps that you can do to expand the 6-year period for you. You see my point?
Yes, sir. Okay. Mm-hmm.
So yeah, I would not
question is here, sir. Actually, I'm working for one company for full-time employee. They are planning to send back to India by this month end, and so that's what they're thinking. If I will go and come back,
this
because
month
my
is
visa
only
stamping.
Tomorrow. This month only tomorrow left.
No. That December end, sir. December end. Sorry.
So, but when is the passport visa stamping ending though?
That is November 17th completed, sir. 2 more months it is having rights, like my which is I have India visiting duration. That they have extended. It went to till January 10th now. So
you have a H1B.
My stamping was there.
Wait. You have a H1B until January 10th, is that right?
Correct, sir.
Yeah, that's the reason why I'm suggesting you is instead of going to India, you go to India. You're subject to the passport stamping, is that right? And there's no passport stamping available until about March ending. That's the reason I'm suggesting you to have an option of probably considering going to Mexico rather than going to India.
Actually, my stamping is not there, sir. If you go to Mexico, also, I don't have stamping now.
Good question. There is something called visa revalidation. If you go to either Canada or Mexico, you spend less than 30 days and you are coming back into this country, you do not need a passport visa to come back as long as you have the valid I-94, which you mentioned to me that you have it until January 6th of 2021.
Correct, sir. That is which is I-797 approved. I have valid.
So you can use that to go to Mexico and come back. Then you can extend that one. You get an idea. Don't go to India, because you go to India, you'll get stuck there for a long period of time.
Yeah, one more thing, sir. My visa stamping recently 2019 it is done actually, 2019 January. So I am eligible for Dropbox actually. Yeah, 2019 January my visa stamped actually. Okay, till November 2020 I have.
Still, I recommend They have extended to 2 years right now. Instead of 1 year of the drop box, they've extended for 2 years. You still need a H-1B approval also, okay, to get the visa drop box. I still recommend you to go to Mexico, but if you don't want to follow it, that's up to you. Even though you're eligible for drop box, I would not want you to go to India. That's me. Okay?
Okay, sir. Actually, my company is not allowing me to go because I'm not able to take leaves also. Yeah,
so
that is
who's
the problem,
telling you to take a leave? Who's telling you to take a leave? Right now, it's everybody is remotely working. You just go spend the time in Mexico. You come back and tell them, hey, I was in Mexico, so I get that extra days. You have to be creative in these things. Okay? Thank you then.
Yes, sir. Yeah, sir. So any chance, sir, when shall we expect this firm approval, sir? Any idea, sir?
That can be any day. That can be any day. It should be
because almost 175 days is done, sir, for me. 175 days is done for me.
Yeah, they're taking about 5 to 7 months right now. It could be any day. Thank you for tuning in, okay?
Okay, sir. Okay, thank you, sir. Thanks a lot. Thanks for your time, sir.
Thank you.
Thank you. Let's admit the next caller here, Andy. And before we take the caller's question, Rahul Garu, I have a question from Rockstar. His question is on H4 EAD, I believe we can't work with the receipt number. We have to wait to get the approval. What about 485 EAD?
485 EAD, there are two things. You cannot work with the first filing of the EAD application though. If it is an extension of the EAD application for the 485 application, you can work on the extension receipt notice. But for the initial application, you cannot work on the receipt notice.
Okay.
For the extension of the AOS EAD, you can up to a period of 180 days.
Okay, well, that's your answer, Rockstar. So here we have the caller, Randy. Please press *6 to unmute yourself. This is a caller ending with 1542. Please press *6.
Hello, can you hear me?
Yes,
sir.
go ahead.
Hello?
Yes, sir, we can hear you. Please go
Hello,
ahead.
can you hear me?
Yes, sir.
Yeah, hi. My name is 𝗕𝗓𝗙𝗀𝗀𝗀. I have a couple of questions actually. The first question is, on my birth certificate, my name is spelled as Nagarjuna. I have an extra A instead of Nagarjun. And my village also spelled as 𝗕𝗓𝗪, T-U-R instead of like P-U-R, it's spelled as P-O-O-R. So will that cause any problem, or do you have to like get some?
It should not. It should not cause any problem. If it's just one A extra and the name is a little bit twisted there, you could be explained that in the translation, especially from the district one, when you transfer it into English, the way they write is completely different though. My own village is 𝗕𝗓𝗪𝗲. You know, you can put it as start with A or you can start with this H, depending on whom you ask. So I've seen the name in both letters, A and H. So you can explain that. As far as your name is concerned, also you can explain it, not a big thing. But I would like you to collect the additional documents, for example, affidavits. What about the ration card? What about the Aadhaar card? What about the, the bank card that you get it? What about the election things, any things which you were being put in the electoral roll, if you have any ration card, school certificate, hospital certificate. I will try to collect all those things and keep it with you, but don't send it to immigration. If by any chance they issue an RFE, you can provide substantial other evidence to substantiate that you are the same Nagarjun who is spelled as Nagarjuna. Okay? That should not be that of a difference.
We already submitted that. Sorry.
Well,
we
that's
already
fine.
submitted. I'm at delivery actually. And my wife.
Yeah, I would not have submitted it. I would not have submitted it. If you have submitted, that's fine. If they issue an RFE, then you can. I normally would not submit those things, all those things. But if you have submitted all these things, what I said, then you should be fine. Should not be much problem.
So I can get an affidavit late, right? I mean, just to be safe. Yeah, and my second question is...
You can go through all the document list that I have told you. If you missed anything, you try to obtain those things. This is in the YouTube, so you can go back and listen to all the documents I listed.
Yeah, sure. Thank you. Thanks for that. And my second question is, my daughter, she just turned 21 on 24th of this month, and my wife she's on H1 and I'm on H4, and my daughter is also on her application. So we applied our application, like my wife's application went to USCIS on 23rd of October. They received it, and my daughter just turned 21 on 24th of this month, and she already had a EB2 approval, and which took like three months and 24 days in EB2. So what we thought is like to get more time to be protected from the CSPA thing. So what we did is we downgraded that to EB3, and she applied. And now the question is, so I mean, the first question, like, is that okay? Will that be considered, like, because she already had an application, right, EB2? So
right.
now,
so are you telling that when you file this 485 application, you also file for downgraded downgraded I-140 application? Is that yes or no?
Sir, that's correct.
Okay. Now, recently, remember I was telling about the Trump administration trying to torch everything that's possibly there. This is CSPA is one of the things that they touched it in the policy change. In the policy change, what they made it very clearly is that they are going to only use the underlying I-140 to detect the age. They're not going to take the previous I-140. They are not going to club previous I-140 and this I-140. They're going to take only one I-140, and that is the underlying I-140 for which you use the adjustment of status. In this case, they are going to use the downgraded I-140 application pending time. They're going to deduct it from your daughter's age. But this is a very technical thing. I would want you to consult a lawyer for it rather than, going with this particular thing. I would want you to consult a lawyer. They recently, just 2 weeks ago, changed their policy on CSPA to clarify the things, and that's not in our favor right now. Okay? Thank you for tuning in.
So that means I'm still eligible, right? My daughter is still eligible for this one?
Right now, her age is frozen from the time this I-140 is pending. Since the adjustment of status and I-140 has been filed before she turned 21, her age is frozen, but we don't know when the I-140 will be approved. I would definitely recommend that you consult a lawyer. I am a lawyer, licensed lawyer, but I'm not your lawyer. So I would definitely recommend that you consult a lawyer. Thank you very much for tuning in.
Actually, I'm planning to take an appointment with you. So if we use the EAD, will she be considered as married to the EAD? And
yes.
On the H1 actually.
She should not be married to this adjustment of status. In fact, Emily and I are planning to do a separate session just on CSPA alone. We're planning to do it this week. You may want to listen to it, but still make an appointment after you listen to it because it's very sensitive for you, I know. Yeah. Okay. Thank you.
Please reach out to Rahul Garu at his
So
office.
she's still considered married, right?
Yes, if she uses the EAD, she would consider to be married. It is very dangerous for her to get married.
No, if I use the EAD,
if you use the
EAD, and
if your wife uses the
she's
EAD,
on H1 right now.
Yeah. If you're, I will answer this question. I would still want you to get, if your wife and you uses the EAD though, okay, and she is an F1, technically she is not married to this application. I want you to, but I want this advice to be taken very carefully. In this case, the daughter is an F1, not an H4. If she was an H4, she would have been considered to be married to this application. Since she is an F1, if you both guys use the EADs, she is an F1, she is still considered to be not married to this application. Okay?
Thank you so much. Please reach out.
So much. Thank you very much.
Thank you, Rahul Garu. I hope he gets the expert advice and he's reaching out to you directly.
Yeah, because of the sensitive issues, what we're doing, and in each topics, we want to make the videos because mine and Emily's appointments are booked up completely. We don't have much space at all. That's the reason we're making specialized videos, especially this particular topic. CSP is very sensitive to a lot of people.
Right.
Any kid who is under 15, 16 years old, they should be very careful about when they should get married to this application.
Right. Absolutely. So that's a separate YouTube channel. You might want to listen into it. Rahul Garu has a lot more to share on that channel. Thank you, Rahul Garu. And we have the next caller here, and the caller ending with 3456. It is 8465, I'm sorry. Let's take a YouTube question, Rahul Garu. Here it is from Prasad. The question he has is, I recently got Canada transfer approval from my employer. Can my employer file I-485 while I'm employed in Canada? The priority date is 9/2018.
9/2018. One thing I want to correct is that the YouTube that we do in the TVASIA Telugu channel covered a lot of topics on the CSPA. They should listen to TVASIA that we presented from past 6-7 months that has a lot of information. Coming to the main question that you put it right now is that Canada, 485 cannot be filed when he's in Canada. He has to be in the country to file a 485 application. They can do something called consular processing, but if the I-140 has not been already filed in the consular processing, just to convert that into the consular processing, it's taking about 2 to 3 years right now. So I don't know, they have to keep a judgment call to see, do they convert the existing application to consular processing, or do they come here and file the adjustment of status? If they're not going to come here at all in the next 2 to 3 years, definitely the best plan is to convert the existing I-140 into consular processing.
Okay. Awesome. We have the caller here, the caller ending with 8465. Please press *6 to unmute yourself, and you can ask your question. You may want to press *6 to unmute yourself. Let's take another question here, Rahul Garu. The question is again from Prasad. Yeah, I think we have the caller. So the question from
Ms. Sita Garu and Mr. Rahul Garu, do you hear me?
Yes, we can, sir.
Yeah, sir, thanks for all the things you're doing for the community. I really appreciate it. I have 2 questions. I filed for my I-485 in the year of 2012. At that time, I didn't have my birth certificate, so I just gave the non-availability certificate. Later in 2014, my dad applied for my original birth certificate and got it. So will I have any problems when I go for the interview, sir? Can I just produce my birth certificate at that time?
Absolutely. You can produce. In 2012, you didn't have it. You had it in 2014. So absolutely no problem. I would also collect the alternative documents. Remember, I was telling the other gentleman, I would also collect all those other documents and keep it with you. Don't provide it to them unless they ask for it. Remember, Aadhaar card, PAN card, ration card, school living certificate, if there is a hospital, ration, I don't know if I covered it. These are all the things that I will also get 2 more affidavits from 2 different family members. Keep it ready. Don't submit it. And then if they ask, some of the officers don't ask. They're fine with non-availability certificate and the affidavits that you have given before. Some of them ask. If you ask, you provide it.
And one more thing is, I also submitted my affidavits when I applied for my 485.
Of course you did. Of course you did.
Yes. Those affidavits were given by my parents. Can my parents provide it, or should it be other than somebody other than my parents?
Technically, it should be other than parents. So try to get it from other people and keep it with you. As I said, don't submit it to them unless they ask for it. Most of the cases in the birth certificate, they just approve it. If you submit to them, and it will raise a lot of questions to them, but get them and keep them with you.
Okay, sir. That's what, with the non-eligibility certificate, right? When I submitted, I just gave the copy of it, not the original. But when I got the original birth certificate, right, the process is I had to surrender my non-availability certificate. So still, providing the original birth certificate when they asked for, right, during the interview, I shouldn't have any problems, right?
No, that should not have any problem.
Okay, sure. Thank you. Thank you so much.
Thank you.
Thank you so much, Andy. I guess we're going to take a couple of more calls, 1 or 2 calls here. Rahul Garu, I have the next caller. While we have the caller, let's take a YouTube question. This is again from Prasad. His question is, I would want to maintain my green card application while working in Canada. I think this is in continuation to the Canada question that we had from him. Any other questions, suggestions in this intra-company transfer scenario?
No, I mean, if he is going to stay there though for a long period of time, he might as well convert the EB-VN application into the consul processing. That is the best thing that he could do.
Okay. So let's take the caller ending. The caller ending with 3456.
Hello, can you hear me?
Yes, sir.
Yes.
Okay, namaste Rahul Garu, namaste Sita. Thanks for doing this. So this is a situation of mine. I have a 2013 March priority date. In EB2, I've downgraded. I've applied for the downgrade. So my wife, who's currently working in a company, she was working till this October in H4 EAD. And from October onwards, she got the H1B. And the company is asking if they could start on the perm processing. Is there any advantage? I mean, she's also in the EAD H4, she's in the 485 as a dependent along with me. We've applied for that. So is there any advantage in applying the perm process?
I mean, rarest of the rare things can happen. Sky may fall down and, and the diamonds can come right in front of me. It could happen, is it right? I mean, who knows? Who expected COVID to come in, is it right? It just fell down from the sky and it paralyzed the entire world. There are some unfold. What if there is a divorce between you and her? I don't know. I mean, there can be many different things, right? I shouldn't say it, but 99% of the time, I don't see a reason why she need a perm application. And she just got a H1B right now. 99% of the only thing that I can think about is that if there is any differences between you and her and you get divorced, that's the only thing that I can think about.
Okay.
But to answer the question, is there any loss in filing a perm application? None. No loss. Absolutely no loss.
Okay. In case once we, if all goes through fine, we get the EAD. If I go, the primary applicant, if I go into EAD, would she still be in H1B where she can be in H1B and her EAD, perm process could be used as a secondary or a backup option?
You can. You can.
Thank you.
So if I go into EAD, if I can, use the EAD.
So wait. So the chances that you're going to use her priority date to become current and you're going to use is 1 in a million chance. I don't want to discuss about it right now. Okay?
Okay.
Thank you so much, sir. Rahul Garu, let's take the caller here, Andy. It is the caller ending with 8689. And before we admit the caller and the question, I have a YouTube question. It is from Ramakrishna. His question is, I have my H1 due for extension in April 2021. I have my bachelor's in electronic engineering and I work as a software developer. Is there any issue with which you can foresee with the H1 extension given that specialty occupation definition changes next week, that is a December 8th?
Absolutely. This guy may be in slight trouble. What I want is that since his extension is not due until April, there is nothing much he can do. What I suggest to Santosh is that file a H1B in premium processing. Get the result before your I-94 expires, because in that way you have 2 chances of getting the H1B. One chance is if you get an approval, that's fine. If you don't get an approval, you get a second chance. You get the second chance to file 1 more extension. Sometimes you may even take a third chance too. Under the current circumstances, with the specialty occupation definition changes, since you have an electrical degree, yes, I would be very cautious and file an application 6 months in advance and also do in premium processing, because if you get a denial, you can file 1 more application.
Okay. So that's your answer, Ramakrishna Garu. We have the caller here, 8689. Please go ahead with your question.
Hi, thank you for doing this. I really appreciate the information you're providing for us. My name is Subhash, and my dad applied. My dad was in the process and got the priority date in 2013 November, and I recently aged out in 21 this April, and when he applied for 2013 for his H-1B extensions, because he took the premium process, because I aged out, and they're not considering that 4 months that I aged out of the application, and it's become a huge problem for me to be part of the application for the priority date of EAD. So I was hoping to ask your opinion on this.
So did you file an adjustment of status with your parent right now, or you did not?
I did not, because when we applied for the recent EB3 downgrade, our lawyer recommended not include me in the application process,
right?
Because I aged out, and he didn't want to take.
Yeah, I think so. The second thing is that the things have changed recently. How to take the CSPA, Child Protective Act. In there, it clearly mentioned that we can't use two I-140s into one. Even if you consider both I-140s, previous EB2 I-140 and the current EB3 I-140, you still aged out, is right? I mean, that was only pending for 4 months. If you deduct the 4 months, which is in April, you turn 21. If you deduct the 4 months from there, it only come to until August. Definitely it doesn't come until October. So unfortunately, I have to say that your dad's lawyer is right in not filing the adjustment of status.
Okay. And one of the things is that I went into F1 last year, and right now I'm working on OPT EAD, initial OPT EAD. So
good.
Do you recommend me to going to take H1B, or do you recommend me to be in STEM OPT EAD?
I would recommend H1B though. The reason is that if you go into STEM OPT, you will have to go through this lottery system. The battle, what your dad did it all these years, unfortunately, you have to do the same battle. You have to do it by your own now, okay? You did it under the guidance of your dad before. You were the secondary person. Right now, you're the main person. You have to do the battle all over again, just like the way Sita Garu did it, I did it, your dad did it. You have to do the battle by yourself. In the process of this battle, though, one thing I will request you, you're a young person, not many young person tune into this kind of TV show. I want you to tune in every week and to listen the updates of what's going on. The second thing is I want you to get to the H1B. I don't want you to rely on STEM extension. There are restrictions on STEM extension. That's one problem. The second issue is that if you have to go to the lottery system of H1B, you know the lottery system, is that right? If you know the lottery system,
right.
if you wait for the STEM extension to go through and then you apply in the lottery at that point of time, you don't get into the lottery, what would you do? You see my point? That's the reason I want you to apply for the H1B as soon as you're eligible, as soon as you have a job, because you have the luxury of movement, you have the luxury of getting into the lottery. So take the H1 opportunity as soon as you can get it.
Yep. Okay, I'm currently working for Bank of America as a SDE. And so another thing would be, so you want me to, and another question would be, is there a possibility that after my parents or my dad and mom get the EAD, could they apply for a family-based green card for me?
Yes, they can. First is they have to get a green card before they can apply for your visa. Before they can apply. And we don't know when their green card is going to come. If it's going to come early, that's fine. But I still have to tell you that there is a backlog for you to get the green card. The backlog is about 4 years for F2B once they get the green card. So they have to get the green card and you still have a 4-year thing. 4-year wait period after that. So my suggestion to you is right now, don't keep much hopes from your dad and mom. Be independent. If something comes in there, of course, they're going to give it to you. I want you to try to battle it yourself out independently. And if something pops up from your dad and they give it to you, that's fine. But I want you to try to battle it out by yourself.
Yeah.
They have to get the green card, not the EAD is not enough for them to file a green card for you.
Okay, right. Thank you very much for that information. And so you want me, my OPT started in July 13, and this year, July 13, 2020, and it's going to end at July 8, 2021. So you want me to apply for H1B as soon as possible and also apply for STEM OPT just in case, right?
Yes, yes, absolutely. I want you to do two things. Apply H1B and apply for STEM extension. You don't know whether you're going to get in the lottery or not. Even if you get in the lottery, you don't know whether you're going to get the H1B approved or not. So do both the things.
Okay.
Okay.
Right. Thank you very much.
Thank you very much for tuning in.
The information.
Thank you.
Yeah, good luck, Stas. Let's take the last caller here, Rahul Garu. This is the caller ending with 5692. And before the caller's question, let's take a YouTube question here. The question is from, it is from 𝗕𝗶𝗱𝗀𝗀𝗀 Garu. The question here is, our L2 extension was withdrawn for my husband and mine as my husband's change of status from L to H was approved. Can you please go on mute, Andy? This is the caller ending with 5692. We are taking a YouTube question before we get back to you.
Hi, good afternoon.
Let's go with the question.
Hi, good afternoon. Can you hear me?
Yeah, go ahead with the question, Andy.
Yeah, go ahead.
Sir, I'm Chaitanya. Currently L1లో వర్క్ చేస్తున్నాను. 2009లో యాక్చువల్గా H1B పిక్ అయింది నాకు. బట్ అప్పుడు చేంజ్ ఆఫ్ స్టేటస్ కన్వర్ట్ అవ్వలేదు, ఓన్లీ నోటిఫై టు ఆఫీస్ అని ఉంది. బట్ ఇప్పుడు L1 ఎక్స్పైర్ అయిపోయింది యాక్చువల్గా ఈ ఇయర్ నాది. సో L1 ఎక్స్టెన్షన్ అప్లై చేశారు. నా ప్లాన్ యాక్చువల్గా ఇండియాకి వెళ్ళి H1 కన్వర్ట్ అవ్వాలని ఉంది మార్చ్లో, బట్ ఇట్ వాస్ క్యాన్సల్డ్ డ్యూ టు కోవిడ్. మళ్ళీ ఇప్పుడు ట్రై చేస్తున్నాను నెక్స్ట్ స్లాట్స్ కోసము. ఇప్పుడు కరెంట్ L1 ఎక్స్టెన్షన్ అప్లై చేసిన దాంట్లో నాకు RFE వచ్చింది. సో దానికోసం వర్క్ చేస్తున్న RFE డాక్యుమెంట్స్ కోసం. నా క్వశ్చన్ ఏమిటంటే, ఇప్పుడు H1 ఉంది కాబట్టి ఇంతకుముందు అప్రూవ్ అయింది, దాన్ని మళ్ళీ అప్లై చేయొచ్చా చేంజ్ ఆఫ్ స్టేటస్ కి సైమల్టేనియస్ గా L1 RFE అప్లై చేస్తాను కూడా నా క్వశ్చన్.
Is it the same company is willing to file a H1B transfer for you right now immediately? The same company that got the H1B approval?
Yes.
They can try it. They absolutely can try it. They can try it. They should try it too. Okay?
Okay. So just the extension of that, if there is any case, ఇప్పుడు L1 ఎక్స్టెన్షన్ కి రిజెక్ట్ అయితే H1 వల్ల ఏమైనా యూజ్ ఉంటుందా దాని వల్ల మళ్ళీ?
There is a chance that they may give a H1B with the I-94. There is a chance they may give it the H1B with the I-94. If they don't though, then you will still have to go to the consulate to get the H1B approval. You would not have much option.
Okay. Okay. Thanks for that.
Thank you very much. You're asking the question from 𝗕𝗶𝗀𝗀𝗀𝗀.
Yes. The question here is that L2 extension was withdrawn for my husband, L1 and mine L2, as my husband's change of status from L to H1 was approved. However, my daughter's L2 status still shows case received. Should we wait?
L2 status still received, but the daughter's H4 is also applied for. It doesn't matter whether the L2 extension has been L2 extension has been withdrawn or not. It doesn't matter. Okay. Her daughter is in a good position because the daughter's H4 has been applied for, so it won't make any difference what happens with that application. And they cannot approve the L2 dependent without the main applicants, so it won't be approved. Main applicants has been withdrawn, the secondary applicant will not be approved though.
Awesome. Okay. So those were the YouTube questions and all the callers. Rahul Garu, thank you so much for the valuable time and the valuable service that you're doing to the community as such.
Thank you very much for everybody, guys. Thank you.
Thank you so much. So if you have any more questions, please reach out to Rahul Garu at his office. Also, he can answer you.